Good morning. This hearing of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties will come to order. Today's hearing will continue the Subcommittee's oversight of the Civil Rights Division of the Department of Justice. Today the Subcommittee The right to vote is the bulwark of our other rights. Without an effective franchise, all other rights are vulnerable. For that reason, our nation's history has been one of fulfilling the promise of our Declaration of Independence and our Constitution by progressively extending the right to vote to all citizens. That struggle has taken generations, but the struggle to ensure that the legal right to vote translates into an actual right to cast a ballot and have it counted remains unfinished. Congress has responded over the years with the enactment of laws to protect the right to vote, most recently with the bipartisan reauthorization of the Voting Rights Act. The hearings we held on the Voting Rights Act demonstrated the continuing need for its protection for voters, especially minority voters and voters with limited English proficiency. I take the Voting Rights Act very seriously. The two counties I represent, or parts of which I represent, are in New York City, are both covered jurisdictions under the pre-clearance provisions of Section 5. We came by that distinction honestly through past misconduct, and I think you will find that most New Yorkers support the continued enforcement of the Act. Today we examine the voting section of the Justice Department's Civil Rights Division. The voting section provides the teeth behind the words of the statute, or at least is supposed to. If the laws ought to have any real meaning, the voting section must be a tireless advocate for the right to vote, without fear of favor and without the intrusion of partisan political meddling. We have received numerous reports over the years that the section is not living up to its mandate, and that politics has, as is the case with other parts of the Justice Department, intruded into the decision-making process, sometimes at the expense of the voting rights of the very people the law was intended to protect. In cases involving the Georgia ID statute or the pre-clearance of redistricting plans in Texas and other jurisdictions, there have been allegations, and I have serious concerns, that the work of the section was swayed by political considerations. We need to get to the bottom of these allegations. The work of the voting section is too important to let these hang in the air. I am also concerned about some comments that Mr. Tanner has made recently about minority voters, which demonstrate to me at best a lack of understanding of the mission with which this section is entrusted. These comments call into question the fitness to head this important section. I look forward to the testimony of our distinguished witnesses. I yield back the balance of my time. I would now recognize our distinguished ranking minority member, the gentleman from Arizona, Mr. Franks, for his opening statement.
Well, thank you, Mr. Chairman, and thank you, Mr. Tanner, for being here. Mr. Chairman, the voting section of the Civil Rights Division protects Americans' voting rights through a federal monitoring program, and the proper functioning of this section is essential to the integrity of our election process. During the course of this hearing, we're going to hear numerous criticisms of the section's enforcement activities and priorities. And certainly that's part of the process, Mr. Chairman, to make sure that we get the facts on the table regarding the section's enforcement activities. Among the most important priorities that I want to emphasize is the difficulty that state and local officials have in confirming the citizenship of voters and preventing illegal non-citizen voters from voting and canceling out legally cast votes. In April, I was glad to see that a federal appeals court in Gonzales versus Arizona rejected an effort to halt carrying out Arizona's recently enacted law that was part of Proposition 200, which passed in 2004. The Arizona law requires residents to prove that they are American citizens when they register to vote and to present identification when they vote at the polls. The ruling by the United States Court of Appeals for the Ninth Circuit said the law did not appear to unduly burden the right to vote or violate federal voting laws or place a disproportionate burden on naturalized citizens or require what would be an unconstitutional poll tax. Arizona's sound approach to voting integrity follows a 2005 report by a group of bipartisan leaders and scholars led by former President Carter and Secretary of State James Baker III. As the Carter-Baker report elaborated, to make sure that a person arriving at a polling site is the same one who is named on the list, we propose a uniform system of voter identification based on the real ID card or an equivalent for people without a driver's license. They emphasize there is likely to be less discrimination against minorities if there is a single uniform ID than if poll workers can apply multiple standards, unquote. Mr. Chairman, a recent Wall Street Journal NBC News poll confirms every other poll on the subject. Over 81% of those surveyed supported a requirement to show a photo ID before voting. This included two-thirds of majorities from African American populations, two-thirds majorities from Democrats, and two-thirds majorities of Hispanics. Requiring photo identification would increase voter confidence. And one of the reasons identified by some minority and low-income voters as to why they do not vote is the perception that they will not be permitted to cast a ballot, or a ballot they cast will not be.
I now recognize the distinguished chairman of the full committee, the gentleman from Michigan.
Thank you, Chairman Nadler. And I want to point out that in the midst of all the work that we're doing in trying to rehabilitate the Department of Justice, and nobody knows more than the members of this committee what we've been through these last 10 months since I've been chairman, there is no section more important to us than the voter rights section, and that's why this hearing is so important to me. We had an oversight hearing earlier, but we want it to be made clear that than in any time in the service that I've been on this committee, it's never been more troubled and disturbing. And so I'm very happy that we have the people on the Constitution Committee working with me on this. We've got to deal with this question, and so what I'm saying is that we've got to work beyond and between these public hearings. The decline in Section 2 cases is unprecedented in the history of the Department of Justice. And we're talking about one case being prosecuted in 6 years. We're talking about the Citizens Commission on Civil Rights that criticized the enforcement efforts made under the tenure of the chief of the voting section, and well before Mr. Tanner's arriving at that position. And we are investigating the fact that career attorneys' recommendations were disregarded with reference to the vigorous enforcement of Section 5, and that not only were they stripped out, but they were rewritten by someone else. We are concerned about the Inspector General's Office of Professional Responsibility, who have raised multiple complaints against the section leader of that section and the staff, and is being investigated in some depth concerning the defrauding the government through the abuse of travel funds. We're concerned about the fact, and some of it approaches the astounding circumstance of people selecting litigation sites based on their vacation travel preferences rather than the merits of the issue. We've got management issues raised by the Section 5 preclearance. And so all of this, don't let me forget, in Ohio, we got a letter from the section, probably from Mr. Tanner himself, defending their decision to maldistribute voting machines disproportionately to the predominantly white precincts at the expense of the minority areas in Franklin County. It goes on and on. I'm going to revise and extend my statement, but we have more grievances, more questions of integrity, more questions about the efficiency of the most sensitive part of the Department of Justice, the voting rights section. And so we've got a big job in front of us. I thank the chairman for allowing me to make some opening comments.
I thank the gentleman. In the interest of proceeding to our witnesses, and mindful of the fact that there's another subcommittee hearing scheduled in this room not too long from now, that we have a lot of witnesses, I would ask other members to submit their statements for the record. Without objection, all members will have 5 legislative days to submit opening statements for inclusion in the record. Without objection, the chair will be authorized to declare a recess of the hearing. We will now turn to our witnesses. As we ask questions of our witnesses, the chair will recognize members in the order of their seniority in the subcommittee, alternating between majority and minority, providing that the member is present when his or her turn arrives. Members who are not present when their turn begins will be recognized after the other members have had the opportunity to ask their questions. The chair reserves the right to accommodate a member who is unavoidably late or only able to be with us for a short time. Our first witness is John Tanner, the chief of the voting section of the Justice Department's Civil Rights Division. Mr. Tanner joined the voting section in 1976 as a research analyst, attended law school at night, and upon graduation was hired under the Attorney General's Program for Honor Law Graduates. In 1995, he left to prosecute criminal civil rights violations, including as a member of the National Church Arson Task Force. He also worked in the White House Office of Counsel to the President, the Senate Judiciary Committee, and the Justice Department's Office of Legislative Affairs. In July 2002, he returned to the voting section to coordinate enforcement of the minority language provisions of the Voting Rights Act and was named chief of the voting section in June 2005. Welcome. Your written statement will be made part of the record in its entirety. I would ask that you now summarize your testimony in 5 minutes or less. To help you stay within that time, there's a timing light at your table. When 1 minute remains, the light will switch from green to yellow and then red when the 5 minutes are up. Before we begin, it is customary for the committee to swear in its witnesses. If you could please stand and raise your right hand to take the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? Thank you. Let the record reflect that the witness answered in the affirmative. I'll begin. The witness may proceed. Would you turn on your mic, please?
Excuse me. Mr. Chairman, Ranking Member Franks, and members of the subcommittee, thank you for the opportunity to appear before you. Let me first note that I have apologized to the National Latino Congreso for comments I made about the impact of voter identification laws on elderly and minority voters. My explanation of the data came across in a hurtful way, which I deeply regret. The reports of my comments do not in any way accurately reflect my career of devotion to enforcing federal laws designed to assure fair and equal access to the ballot. I began working to secure equal voting rights as a teenager in Birmingham, Alabama in the 1960s. I spent time on weekends at the SCLC headquarters stuffing envelopes. I took African American citizens to the federal examiners to register to vote. And I embraced a vision of a just society, African Americans in elected positions in city halls, county courthouses, the state legislature, and in Congress from Alabama. In 1976, I joined the voting section where I pursued that vision of a just society through voting rights enforcement actions. In the high point of my career, I helped obtain fair representation for African Americans in the Alabama legislature using Section 5 of the Act, which we are now vigorously defending against a constitutional challenge. I also helped obtain a Mississippi legislative plan that added 20 new African American legislators, and I brought cases in many other states. I'm honored that my work has been recognized by the Conecuh County Branch NAACP, the Concerned Citizens of Bessemer, the Alabama Democratic Conference Young Democrats, the Greenwood, Mississippi Voters League, and the City Council of the District of Columbia. I worked outside the voting section from 1995 to 2002, serving at the White House Office of Counsel to the President, the criminal section of the Civil Rights Division, the Senate Judiciary Committee, and the Department's Office of Legislative Affairs, where I worked with members and staff of this committee. I returned to the voting section in 2002, assigned to lead the section's efforts in enforcing the minority language provisions of the Voting Rights Act. Since 2002, the section has filed twice as many such cases as in the entire previous history of the Act. During that time, we have filed a majority of all cases ever filed under the substantive provisions of the Act on behalf of Latinos, a majority of all cases on behalf of Asian Americans, and over 70% of all cases ever filed under the voter assistance provisions of Section 208. Since I became chief in June 2005, I have worked to protect and extend the voting rights of all minorities. We changed the election system in Euclid, Ohio this year to open the door to African American representation. We have used Section 5 to block discrimination in Alabama, Georgia, Texas. I reached out to African American groups to seize new opportunities to protect the rights of African Americans and to other groups protected by our statutes. Arab Americans, Native Americans, Latinos, Asian Americans, and persons with disabilities. During my 31-year career, the section has averaged 8 new cases per year. Since I became chief, our pace has nearly doubled. In 2006, the section brought 18 new cases, the highest number in any year in history. These have been important cases. We have seen segregated polling places, ethnic slurs, race-based challenges, voters leaving the polls in tears, and ballots actually taken from voters and marked contrary to their wishes. We go into court to stop these practices. The section is so productive because of the energy, the enthusiasm, and the commitment of the section's staff, a group of talented self-starters eager to find and combat discrimination. I have to make hard decisions. Ultimately, all of my decisions are made after careful scrutiny of the evidence and are based solely on the facts and the law. I am blessed to be in this position, which enables me to continue to work towards realizing the vision of a just society I embraced over 40 years ago in Birmingham, and to help this nation realize its own vision of equal voting rights for all. Thank you for your attention. I appreciate the opportunity to respond to any questions you may have.
Thank you, Mr. Tanner. I will begin the questions by recognizing myself for 5 minutes. Mr. Tanner, in April 2005, while you were serving as the voting section chief, Georgia passed a law requiring photo identification in order to vote. Georgia submitted this law for Section 5 pre-clearance. We now know that 4 out of 5 of the Justice Department civil service employees objected to the law and forwarded a 51-page memo to you that included a factual investigation and a legal review of the Georgia plan. Most significantly, the memo included a detailed analysis and a recommendation that the department object to the voting change because it was likely to discriminate against black voters, but they were overruled the next day by higher-ranking officials at Justice. Only 1 day after receiving the staff analysis recommending an objection, the department approved the Georgia plan. Brad Schlossman and Hans von Spakovsky, both former senior-level Department of Justice officials who served in the CRT, testified before the Senate that you played a key role in the department's decision to approve the Georgia photo identification law. Now, you received the 51-page memo that analyzed thousands of pages worth of information on August 25th. The department received additional information from the state of Georgia on August 26th. So is it your position that you had sufficient time between August 25th and August 26th, 1 day, to conduct a thorough review of the staff memorandum and the new information the department received from Georgia?
Thank you for your question, Mr. Chairman. You've raised an important issue, and I'm happy to have the opportunity to address it. Consideration of the Georgia ID statute began, I believe, even before it was passed, and certainly before it was received by the department. I recall meeting in Georgia with Mr. McDonald, who's on the next panel, and discussing it before we received it. I entered that process. I approached the review of the decision, frankly, with the presumption that we would interpose an objection to it, that we would determine that it was racially discriminatory. My presumptions ran into the facts, however. It turned out that the statistical data, the facts before us, the best facts available, which is what I have to make my decisions on, demonstrated that it did not warrant an objection under the very narrow standards and the very narrow inquiry under Section 5 of the Voting Rights Act. I'd be happy to discuss the precise scope of our review under Section 5, but
before you get into that, we'll get into that in a moment. The staff recommendation said that it did was the 4 out of 5 staff members who reviewed it said that you ought to recommend it interposing an objection. You overruled that. Is that correct?
I made the decision
that they were incorrect and that you should change the recommendation.
I made the decision, Mr. Chairman. I'd like to make that clear. I would, of course,
but in making that decision, you differed from the 4 attorney or whoever, the 4 of the 5 people, the staff people, the permanent staff who recommended a contrary decision, correct?
I'm in an awkward position in that we are not allowed, and it is inappropriate for department personnel to discuss internal deliberations and the confidences of our clients. I'm happy to give you information and explain the basis for my...
Mr. Tanner, I believe that is public information that has been testified to before I think the Senate. Is that not correct, that this is public, that the 5 individuals who reviewed this, who did all the staff work for them, recommended disapproving, and one differed from that? That's all public information at this point.
I'm not aware of the testimony on that. I'm not going to deny it. I will say that I made the decision, and my decision was based on a careful analysis that had been ongoing for a considerable period of time. There were, as is typical in such situations, numerous discussions, detailed discussion of the data, and a number.
Before you did that, did you forward that to the front office, or did you get approval from the front office?
The internal memorandum was forwarded to the front office. The matter had been had involved a large number of discussions over an extended period and very careful analysis and review by me.
Now, but is it not true that it was a long-standing section practice for a section chief who disagreed with a staff recommendation to submit a separate recommendation and leave the final decision concerning the split recommendation between staff and section chief to the Assistant Attorney General?
I think that the Assistant Attorney General was fully aware.
That wasn't my question. Was it or was it not a long-standing practice that when the section chief disagreed with the staff recommendation to submit a separate recommendation so that the Assistant AG could see the separate recommendations by the staff and by the section chief, and he could make a decision, or she?
That has not been the uniform practice.
Was it the general practice?
I will say,
I know it wasn't uniform because you didn't do it. Was it the general practice up to that point?
Well, prior to that time, it had not been done. As I mentioned, I was outside the section from 1995 through 2002, and I was not involved in Section 5 review of voting changes until I became chief to any significant extent, so I can't speak authoritatively about the practices during that time. I have made changes in the Section 5 process, and I'd be happy to discuss those.
Who has the burden of, in a Section 5 submission, who has the burden of proof? The submitting jurisdiction to prove that it doesn't violate the, that it doesn't negatively impact the minority voting rights, or the objecting parties?
The statute is clear that the burden is on the submitting authority to establish its.
Okay. And what were the facts that met the burden of proof in this case?
There were three key facts to me in the case. The first were data showing, much to my surprise, frankly, and contrary to my expectations, that statistically the number of people in Georgia who had the requisite identification, the requisite photo identification from the Department of Driver Services alone actually slightly exceeded census estimates of the population eligible to possess that ID. That was the first fact. The second fact that was very significant to me was the very large number, over 700,000, I believe, persons in Georgia who had non-driver's license IDs, which met significant issues in the case. And finally, each of 4 data sets showed uniformly that the proportion of that minorities were slightly more likely than white persons to possess the requisite Department of Driver Services identification. Those facts met the state's burden of showing that it would not discriminate, where essentially or statistically all persons had the ID and minorities were more, not less likely.
And I'm not going to go into the fact that some of those figures were quite erroneous, and that Georgia had to correct them. And yet, despite everything you just said, the federal court reversed the decision and said that this was quite incorrect.
You've made an important point, Mr. Chairman, and I think it's good to address. The federal court in Georgia rejected the claim that the Georgia ID law was racially discriminatory. There was a claim under Section 2 of the Voting Rights Act, which is the closest parallel among the claims to the Section 5 inquiry. The court did reject the plan on other bases, on constitutional bases, which are outside the scope of our review under Section 5.
Poll tax is outside the scope of Section 5 review?
The only thing that we can look at under Section 5 is a narrow question of whether a voting change would be retrogressive. That is, it would make things worse for minority voters relative to white voters, or at that time, if it had the purpose to retrogress. Yeah. We cannot interpose an objection based on a constitutional violation or a statutory violation that does not meet that narrow standard.
Okay. Thank you very much. My time has expired, and I now recognize the gentleman from Arizona, the ranking member, Mr. Franks.
Well, thank you, Mr. Chairman. Thank you, Mr. Tanner, for being here. Mr. Tanner, just I'm sure it's a little bit redundant and ask you to repeat yourself a little bit, but would you give us your understanding of the Federal District Court ruling on the challenge to the Georgia voter ID law?
The initial federal court ruling, which was in the preliminary injunction stage of the case, addressed a number of claims, including constitutional claims, the poll tax and the equal protection claim, as I recall, that were, as I said, completely outside the scope of Section 5 review, which is, as I described it, does the voting change make things worse for minority voters relative to white voters? There was a similar claim under Section 2 of the Voting Rights Act, which is a general claim of discrimination. And the court, while issuing preliminary injunctions on the constitutional claims, declined to issue such an injunction, rejected that claim, the preliminary injunction stage, as it did other statutory claims under the Civil Rights Acts. I don't recall the exact details of those.
Well, Mr. Tanner, as far as the 2008 elections, what steps have you taken to make those elections come off in a way that is the most just for voters in general? Give us an insight into what some of your priorities are there.
The first thing we're doing is conducting active litigation on election day type issues. Since I became chief, we've brought 23 cases under the Voting Rights Act itself the Voting Rights Act alone. We've also brought cases under our other statutes that protect overseas voters and other voters here in the United States. We also have been conducting very active Election Day monitoring. In the 2004 election, we had 1,999, or during the course of 2004, we had nearly 2,000 people out monitoring the polls. Every year, we set a new record of placing people in the polls in key areas to make sure that we can address such problems as arise on Election Day and also get evidence to go forward and address problems in the future. I also have been reaching out to minority groups, as I said in my opening statements, of all types of minority groups to work with us to first help us identify problem areas, areas where issues within our statutes are likely to occur, to help us obtain information and to help us gather that information in a way that it later can be used as evidence in federal court.
Well, Mr. Tanner, let me just ask you what do you think are your greatest accomplishments during your tenure as chief? What are things that you think you've accomplished? What do you intend to do in the future?
I think that my greatest accomplishment, which actually began before I was chief, was to develop a system to addressing the specific minority language statutes that I was responsible for enforcing, so that we have a regular flow of such cases, so we're doing a record-setting job every year of addressing those issues and bringing lawsuits. My challenge now is to develop similar systems under each of other statutes, and I'm making significant progress in that. We're reaching out to African American organizations, Arab American organizations, and others whom we had not reached out to before to make sure that we get as much information and do as much for everyone as we possibly can.
Well, thank you, Mr. Chairman. Mr. Tanner, the Carter-Baker report on election reform, I'm sure you're probably more familiar with it than anyone on this panel. But they reported that a substantial number of Americans are registered to vote in 2 different states. And according to those news reports, Florida has more than 140,000 voters who apparently are registered in 4 other states, in Georgia, Ohio, New York, and North Carolina. This includes almost 64,000 voters from New York City alone who are also registered to vote in Florida as well. Voting records of the 2000 election suggest that more than 2,000 people voted in more than one of those states. Duplicate registrations are seen elsewhere. And as many as 60,000 voters are reportedly registered in both North Carolina and South Carolina. How do we address that? What has been your approach to that issue?
The issue of people voting in 2 different states or voting twice would fall within the jurisdiction of the criminal division of the Department of Justice. Our office enforces the civil laws that are designed and do a great job of providing voter access, but we do not do criminal enforcement in our shop.
Thank you, Mr. Tanner. My time's up. Thank you, Mr. Chairman.
Thank you. I now recognize the distinguished chairman of the full committee, Mr. Conyers.
Thank you, Chairman Nadler. This is a kind of a hearing in which we get 2 diametrically opposed reports of what's going on. We call this hearing because we are gravely disturbed about the ineffectiveness and the activities that have gone on within the voter section. And the voter section chief comes to us this morning to tell us he's never been more proud of the voter rights section and its accomplishments, and further that he's got the greatest group of people energetic, committed to voter rights activity and its promotion. And as a matter of fact, it's never been better. And I think what we're seeing here with the Georgia voter ID case just starts off this discussion, which we've been on. I didn't know we were going to be on it for so long. But the bottom line of all of this is is that there wouldn't have been any Georgia voter ID law if your department had followed the recommendations of your career lawyers. And it was because you overturned their work and decided to do something differently, we now have not only Georgia voter ID, but we have other places which are screaming about voter fraud. The last time I looked, we had 82 individual cases of voter fraud that were prosecuted over the last period of 6 years. And so it seems to me that this is a hearing that we're going to go over sentence by sentence. Now, having said that, and I noticed that the gentleman from Georgia, John Lewis, was over here for a while. Still is. I want to turn very quickly to Ohio. You see, the chairman of this committee and I were in Ohio, in Columbus. We had a forum. We had members of Congress, Stephanie Tubbs Jones, Sherrod Brown, and other members, the now governor of Ohio, and others were there. And I want to tell you, Mr. Section Chief, I never met so many hundreds of people furious about the process that characterized the elections in Ohio in November 2004. Never in my life, and I've been south and north in this situation. And yet you explain that, and there were African Americans and white people, Democrats and Republicans, people that worked in the electoral process, all furious about the misstatements, the deceptive practices, the purges that went on. And your letter that says allowing for problems of incidents in individual precincts, it appears that to be the tendency in Franklin County for white voters to cast ballots in the morning, i.e. before work, and for black workers to cast ballots in the afternoon, i.e. after work. We have established this tendency through local contacts and through both political parties. Now, that was the only thing that nobody complained of, as I recall that hearing. That was the one thing that was not the problem. The problem that there were people purged. There were incredible misstatements by the Secretary of State at that time. The weight and the quality of the paper that one must supply for a ballot was all on there. And so I would refer you to the book, What Went Wrong in Ohio, that documents the incredible activities that took place there. And for you to have sent this letter does anything but demonstrate, the one you sent to Franklin County from the Department of Justice, it demonstrates anything but your concern about voter rights enforcement and encouraging the vote. Now, I just want to conclude. We have a lack of prosecution in the voting rights section. We need to do a lot more in your section, and I'm hoping that you will take what will be directed to you as constructive, because the one thing I'm concerned about is that we stop having happen what's happened since the 2000 elections, and then you come here to stagger our imagination by telling us that it's never been better. It's never been worse.
Time of the gentleman has expired. I recognize the gentleman from Indiana for 5 minutes.
I would welcome an opportunity to comment on the Chairman Conyers' observation.
It's expired.
Okay.
We'll make it later.
Certainly. Thank you.
Thank you, Mr. Chairman. I'd be pleased, Mr. Tanner, if you'd like to respond to Chairman Conyers' question during my time. You may proceed.
Thank you very much, Mr. Pence. And I'd like to thank Chairman Conyers for the work that he did do in Ohio, where there were a lot of issues raised for all parts of the election process, issues that properly come before our office, the criminal division of the civil rights, many issues that come before fall within the jurisdiction of state officials, and many issues for this Congress to consider and address. And I appreciate your leadership in that and your report, which actually was the thing that spurred the investigation. From the report by Chairman Conyers, I determined that there was a good likelihood of a potential for a lawsuit in Franklin County. We went there, we gathered facts that fit into our statute, and many of the problems mentioned by the chairman are things that happen outside of the county, that happen at the state level, and that had already been addressed. I don't apologize for those things or defend those things, but I do note the context. The statistics in Franklin County showed that in terms of the actual voters who showed up on Election Day, there were more voters per voting machine in the predominantly white precincts than there were in the predominantly African American precincts, contrary, which was not the same as the voter registration data. We looked into it. We talked, as we mentioned, to both parties and other knowledgeable individuals, and ultimately, as I always must do, I based a decision after careful scrutiny on the facts and on the applicable law, and made the complex, lengthy decision whether or not we can prove a violation of a specific statute in federal court.
Thank you for that. Reclaiming my time, I'm happy to extend that courtesy to you. I want to appreciate very much your apology today and the clarification of the comments that you made at the recent meeting of the National Latino Congreso. I want to acknowledge your 3 decades of commitment to civil liberties and to protecting against discrimination, particularly in the ballot box. I voted in favor of the Voting Rights Act reauthorization last year. I disagreed with some members of this panel on my side of the aisle in defending bilingual ballots. It may just come up in a minute or two. But let me also offer, I'd like to, Mr. Chairman, if we could submit in the record the strong letter of recommendation directed to you from the American Arab Anti-Discrimination Committee, a record that describes our witness as an individual who's, quote, gone above and beyond the normal call of public servant to listen, work, and incorporate the input of a diversity of communities, and extols his dedication of 30 years of his life to fighting discrimination.
Without objection.
I just ask, in my remaining time, Mr. Tanner, you know, there's so much controversy in the last presidential election over accusations of the rights of minority voters being infringed upon. Could you speak about any steps your division has taken, you've personally taken, to prepare for the 2008 elections? Can you give us assurances that the voting section will respond to problems of the kind experienced or alleged to be experienced in 2000 and 2004?
I'd be happy to, and I appreciate the very important question. We have begun reaching out, and began some time ago, to reach out to the groups that monitor elections, as I did before the 2004 election, to minority groups across the spectrum. I very much appreciate the letter from the Arab American Anti-Defamation Committee, because they may well be the group that in many ways is most vulnerable because of all the circumstances of this country, and I feel that we have a particular obligation to protect them, but also to many organizations, the NAACP, the Lawyers Committee, the NAACP Legal Defense Fund, the National Congress of American Indians, the LULAC, MALDEF, NALEO, groups across the spectrum, so that we can work together, so we can do the best possible job anticipating problems, getting information early enough to make the difficult decisions, not only about where there might be a problem on Election Day, but where we should have someone stand, in which building they should be. It's very complex. It's very important. We've been doing more of it than ever. And 2008, and the time, as Mr. Conyers mentioned, between now and 2008, is such an important time. There's not a lot of time, and there is an awful lot to do.
Thank you. And before proceeding to our next question, I simply want to recognize and welcome the presence of one of the giants of the civil rights movement and the struggle for voting rights, our colleague, the gentleman from Georgia, Mr. Lewis, and to welcome him here today. And I recognize the gentleman from Alabama.
Thank you, Mr. Chairman. Mr. Tanner, good morning to you.
Good morning.
I echo the concerns that Mr. Nadler and Mr. Conyers raised. I did note a number of letters that you submitted. Mr. Pence just alluded to some of them. People with whom you've worked in the civil rights community, I think you submitted some letters from some people I know in Alabama. There's only one problem with letters. Someone somewhere once said, but only people with bad credit need cosigners. But let me turn to a more important observation than that. You apologized at the beginning of your comments today for the statements that you made. I'm not 100% sure what you're apologizing for. I'm not sure if you're apologizing for how people read the statements or if you're apologizing for making them. So I want to give you some chance to be more specific about that. I want to read you a quote, and first of all, tell me if you said it. Quote, "Our society is such that minorities don't become elderly the way white people do. They die first." Did you say that?
That was part of my statement, Mr. Davis, and I welcome.
Well, I just want to ask you if you said that, and you've said that you did. Is that an accurate statement?
It is a sad fact. And
is it an accurate statement?
I believe that the census data show that life expectancy in Georgia, anyway, which is what I was addressing, is lower for African Americans.
Well, you don't say that. You say that minorities don't become elderly the way white people do. Is that accurate?
It was a very clumsy statement.
Is it an accurate statement?
I believe that I've said, Mr. Davis, I may not completely understand the question.
The question is it accurate that minorities don't become elderly the way white people do?
The statistical data indicate that life expectancy is lower for minorities.
Then you say people. They die first. Who is the they?
I was addressing the sad fact that the inequities in this country are such, and I'm not an expert on all of those inequities. I know that members of this committee.
Well, let me slow you down because we only have 5 minutes, and you'll have an opportunity to respond to our comments when my time is precious. Let me ask you this. My state of Alabama, 2004 presidential election, what percentage of minorities do you think voted in that election for president, Mr. Tanner, in my state of Alabama?
I do not know the figure, and I would like to make sure before I give any information.
Do you have a ballpark guesstimate?
I don't have an estimate. I would have to.
Number was 73%. Do you happen to know what percentage of whites voted in my state in the presidential in 2004?
I also do not know that.
The number was 74%. Do you know what percentage of those minority voters were elderly in my state?
It's my belief, but I would have to check the data, that elderly voters in Alabama, many of whom I worked with, are more or have good turnout.
Yes, elderly voters have good turnout, and in fact, minority elderly voters have very good turnout, don't they, Mr. Tanner? In fact, just to frame this in terms of statistics, in my state of Alabama in 2004, of that 73% black voter turnout, 40% of them were over 60. That is actually a higher percentage than in the white community. So if you look at the statistics rather than your stereotypes, elderly blacks are more likely to vote than elderly whites. And I think this is, did you also make the comment, by the way, that blacks are more likely to go to check cashing businesses at some point in Georgia? Did you make that observation?
In addressing the Georgia...
No, don't give me a long answer. I don't have the time. Did you make the comment or did you not make it?
I made a comment about that.
Okay, now, this is the point, Mr. Tanner, that I think we want to drive home. Do you have any statistics about how many blacks visit check cashing businesses versus the number of whites who do?
Excuse me. I do not have any with me, but I believe that such statistics about the number of unbanked persons here in the United States by race would be available through the Office of Comptroller of the current.
Do you know those numbers?
I do not know those.
Well, this is the problem. Once again, you engaged in an analysis without knowing the numbers. And the point, Mr. Tanner, if I can just finish my observation, Mr. Chairman, you're a policymaker, sir. You are in charge with enforcing the voting rights laws in the country. And if you are not fully informed about things that you're talking about and pontificating about, if you're basing your conclusions on stereotypes and generalizations, that raises a question in the minds of some of us whether or not you are the person best positioned to make these choices. You said that minorities don't become elderly the way white people do. They die first, and you say, well, that was a horrible generalization on my part. You say you don't know how many elderly minorities vote versus the number of whites who vote who are elderly. You make observations about people going to check cashing places, and you suggest that, well, because blacks go to check cashing places, they surely must have photo ID. And then I ask you if there's a statistical basis for that. You say you don't know it. If you are basing your conclusions on stereotypes rather than facts, then it suggests to some of us that someone else can do this job better than you can.
I welcome an opportunity to address that. I did not make my decisions based on assumptions. We looked at the numbers. I had been surprised by those numbers, and I was trying to...
Did you look at numbers regarding elderly minority voter participation? Because those are the relevant numbers.
The relevant numbers, I believe, that I looked at were whether or not there were people who did not have photo ID in Georgia. And the statistics...
Did you look at numbers regarding elderly minority voter participation? And can you cite those numbers to the committee?
The data showed that everyone in Georgia, that there were more people who had the ID of all ages, more voting age people who had the ID than there were voting age people who were eligible to have the ID.
Did you look at the percentage of elderly minority voters in Georgia?
In making the decision, I looked at the facts that were relevant to the...
Did you look at the percentage of elderly minority voters in Georgia?
No.
Thank you.
The gentleman's time has expired. Gentleman from Iowa.
Thank you, Mr. Chairman. Mr. Tanner, I appreciate you coming before this committee. And at first, I'd ask you, you have testified that your statement that brought about this hearing was clumsy. And I want to give you an opportunity with clarity to state before this committee, do you believe that your statement remains supported by empirical data and fact?
I again apologize for the statement. I do believe that the statement with respect to life expectancy, that it is a sad and sorrowful fact that in this country or in Georgia at least, which is the place I've looked at the data, and each state must be considered separately, the life expectancy is lower among members of minority groups. I believe as to the other observations, speculations, that there are data supporting those observations. And I very much, as in any time when someone disagrees with a proposition I've made, to receive evidence or information that corrects it. I realize that I do not know everything. I welcome new information.
Okay. Thank you, Mr. Tanner. And I'll boil that down to, if the facts support your statement, then why do you think that you're here before this committee?
Well, I welcome the opportunity to explain what I do before the committee. I certainly made the statement, an observation in a very clumsy way.
I've asked you an inappropriate question because in the end you have to speculate on the motives of some of the questions that are being asked of you. But I wanted to point out that there's a difference between being factually correct.
Would the gentleman yield for a moment?
I would yield.
Thank you. As chair, I simply want to point out that this committee is not having this hearing simply because of a statement made by Mr. Tanner. It's one in a series of hearings on the voting rights section and on the civil rights division, and would have occurred regardless of any statements he made. We have it had been prepared, it had been scheduled long before these recent statements, so the hearing would have occurred in any event.
I thank I thank the chairman for that clarification, and as I said, I really intended to withdraw the question because it put the witness in a bad position, and so I would continue on, and that would be, I think it's important to note that if a statement is made publicly and it's supported by the facts, then the subject comes down to then was it insensitive or wasn't it? You've already spoken to that. I'm ready to accept that as a definition of what happened and moved on. But I think it's important here that we often are debating things beyond the facts, and sometimes a person's criticized for a factual statement, but there's not opposing documentation of another group of data that would rebut that. And that seems to be what I'm missing here. I wanted to ask you, you've testified that you brought 23 different cases under your jurisdiction. How many investigations have you launched? Do you know the answer to that?
I do not know the exact number of investigations. We have a number of investigations that are ongoing, some of which are very near fruition.
Would it be in multiples of the 23 cases?
It would be far more than 23.
Are we talking hundreds or thousands?
It would be in the range of hundreds.
Okay, that gives me some concept of that. And should the law be colorblind, Mr. Tanner?
I think that the Constitution protects all citizens of this country from discrimination on the basis of their race.
Excuse me, I'm watching my clock tick down. And the question goes then to the Voting Rights Act, because the Voting Rights Act, in fact, is not colorblind, is it?
The Voting Rights Act is a very important remedial statute directed to address a long and, frankly, appalling history of discrimination in this country. The Act protects all citizens without regard to their race.
But I will state this then and ask you to disagree. I will state again, the Voting Rights Act is not colorblind. Do you agree or disagree?
I think that the Voting Rights Act recognizes the special discrimination that has occurred against members of racial and language minorities.
Sorry, Mr. Tanner, I recognize that, and so you don't disagree with my statement, but you'd like to expand it a little more, and I just don't have time for that. And I'd ask you, has it been brought to your attention that there have been local jurisdictions that have passed what one would view as anti-illegal immigrant ordinances within their, say, their county jurisdictions or within voting jurisdictions that you might be aware of?
There is a great deal of tension about the immigration in this issue in this country. Certainly, that's something that we're aware of, and especially as it interacts with the voting process. Have
some of these organizations that advocate in favor of illegal immigrants met with you? Have you had conversations with them? And I would say in particular maybe La Raza, MALDEF, and LULAC?
I have met a number of times with representatives of La Raza, MALDEF, and LULAC.
And have they ever asked you to bring an investigation into a jurisdiction that has passed local ordinances that would be supportive of laws to enforce our illegal immigration?
Those organizations have brought issues to our attention as they affect the Voting Rights Act.
Have they asked you to intervene in any of these jurisdictions, in particular Prince William County, just across the river?
Well, we have received inquiries about the voting situation in Prince William County, as we do from other groups all across the United States.
Have they asked you to investigate in those jurisdictions?
I don't know that we have discussed those jurisdictions. Well, we have discussed Prince William County. I have discussed Prince William County with representatives.
I thank the witness, and I watched the clock here, and I'll have some other questions to submit in writing. I appreciate the opportunity, and I'd yield back the balance of my time.
I'd welcome that.
I'd be happy to let the witness answer.
Witness can answer the question.
Answering questions about legal issues can sometimes be difficult to do in very short language, and I apologize for that. I was not trying to be evasive. I was trying to tell you what we have, in fact, done. And thank you for the time, Mr. Chairman.
Thank you. And now recognize the gentlelady from Florida.
Thank you, Mr. Chairman. Mr. Chairman, first I'd like to ask unanimous consent to submit this article for the record from the New York Times of April 12, 2007. The headline is, "In 5-Year Effort, Scant Evidence of Voter Fraud."
Without objection.
Thank you. Mr. Tanner, it's a privilege to be able to spend some time talking to you about this very important issue. You mentioned in your opening remarks that the purpose of the voter purging effort from your division was the result of a pursuit of voter fraud. And my colleague, Mr. Franks, referenced the state of Florida and numbers something like 2,000 people who were listed as voting in both Florida and in another state. When former Attorney General Gonzalez was here and we had an opportunity to question him about voter fraud, pursuing voter fraud being a priority of the Department of Justice and what a grave concern that was, he was unable to produce any significant evidence of widespread voter fraud, particularly deliberate voter fraud. And I will reference the Federal Election Assistance Commission analysis that specifically said that despite the Department of Justice's pursuit of voter fraud, and despite your testimony just now that it is in the hundreds as far as convictions, only about 120 people have been charged and 86 convicted as of 2006 with voter fraud. And most of those, number one, were Democrats, and number two, were found to only have mistakenly filled out voter registration forms or misunderstood eligibility rules. So my question is this. I would think and wholeheartedly support that the pursuit of voter fraud, particularly deliberate voter fraud designed to impact an election, would be a worthy goal. But it doesn't appear that the Department's pursuit of voter fraud has turned up any evidence of that, very little, in fact. And my specific question is that at any time during your tenure as chief, have you drawn up a list of voters that were thought to be ineligible to vote or ought to be removed from the rolls as part of your Section 8 enforcement activity? And if so, in what states or cases and what methodology was used to create that list or lists? And the reason I'm asking you is that in 2000, and I'm from the state of Florida, our former Secretary of State and former colleague here in the House, Katherine Harris, purged 100,000 voters from our rolls in Florida who were eligible to vote. And so a widespread effort on your part and the part of your division to do that, especially in light of the fact that there has been scant evidence of voter fraud and less than 100 convictions from your department, seems that this is an overzealous activity that rather than continue to focus on that, you should be pursuing the low-income registration that you have completely abdicated your responsibility to do, and that is part of your mandate under the law.
I welcome the opportunity to address your question. First, our section has nothing to do with voter fraud. The criminal division of the Department of Justice prosecutes cases of voter fraud. Our statutes are voter access cases. We do have...
but what is the purpose? Then if your section has nothing to do with voter fraud, what is your department's purpose in pursuing purging of voters from the rolls? What's the reason for doing that?
Under the National Voter Registration Act, passed by the Congress and signed by the President, there are list maintenance requirements that, first
I understand
of
all,
that. Require notice before anyone is purged, and that also require that persons who have died are no longer.
Let me just interrupt you a second, because I want to make sure that rather than expounding, you're answering my question specifically. For example, I understand the general purpose of purging, but the priority that your division has made it is what deeply concerns me, especially given the track record from my home state. In 2007, a lawsuit was dismissed from the Justice Department that was filed against the Missouri Secretary of State, alleging that her office failed to make a reasonable effort to remove ineligible people from local voter registration rolls. It was dismissed because the judge ruled that the government had provided no evidence of fraud. I don't understand why it appears to be such an important priority, since voter purging really seems to mostly just be an administrative function, and in my lifetime has always been treated as an administrative function, but your division has elevated it to a massive priority, and you just testified that your division has no responsibility for pursuing voter fraud. So why?
Counties in Missouri were removing voters from the active voter list without the notice required by the NVRA. They were removing voters. Other counties were not removing voters, and there was a county that had more voters on the rolls than they had people.
They purged 50,000 in 2002, and in spite of that, you pressured them in 2005 to remove more, even though they were very likely being cautious about removing voters from the rolls so that they could avoid the problems that they had had 3 years before.
I think it's accurate to state that voters were being removed in Missouri without notice.
And you were encouraging them in 2005 to remove more.
We sued them to stop them from removing voters without notice. That was a count in our lawsuit.
Well, it was the primary purpose of your lawsuit was that Missouri was failing to make a reasonable effort to remove ineligible people from local voter registration rolls, and that was dismissed in April of 2007. Isn't that correct?
The case was dismissed because the court determined that we had to sue each of the individual counties that was removing voters without notice.
But a component of your lawsuit was that the office in Missouri had failed to make a reasonable effort to remove ineligible people from local voter registration rolls, not what you are representing here today as the primary purpose.
There were two purposes, both.
And you're conveniently only choosing to talk about the one that was not related to pressuring them to remove ineligible voters from the rolls, even though 3 years before they had made a mistake in removing 50,000 voters from the rolls. Isn't that right?
I believe that the complaint, which addresses both issues, speaks for itself. We'd be happy to provide additional documents to the committee, but we are...
Thank you, Mr. Chairman. My time has expired.
Thank you. The gentleman from Minnesota is recognized for 5 minutes.
Exactly what are you apologizing for?
I hurt people.
How did you hurt them?
The reactions of people to my statements, which were very contrary to what I was trying to communicate.
So are you apologizing because of the reaction people had to your statements?
I caused that reaction, certainly not intentionally. I made clumsy statements.
So what was clumsy about what you said?
I'm sorry, excuse me.
What was clumsy about what you said?
I believe that what I was thinking.
No, what was clumsy about what you said?
I was addressing a narrow issue of the statistics needed to show a violation of federal law in a very clumsy tone, the tenor of my remarks.
So you're apologizing for your tone?
I am apologizing that my tone caused this. I believe that I am responsible.
So the problem is the tone?
I certainly had a bad tone and clumsiness to the.
Is it true that minorities die soon, so that the voter ID laws just don't affect older people of color the same way that they do other people?
I never, ever meant to suggest.
I don't know what you're apologizing for. You say that you were right, but your tone was wrong. I don't know what you're saying you're sorry for. Could you please help me understand, if you're claiming that you're statistically correct, why are you apologizing? Are you trying to just curry favor?
I'm not. I feel that if I make remarks that people misinterpret.
So people misinterpreted what you said.
I apologize for that.
Now, wait a minute. You said, I'm sorry, did people misinterpret what you said?
I believe I said it in a way that did not communicate effectively.
Minorities don't become elderly the way white people do. Is that true?
I think that is clumsily stated.
Is it true?
People age in the same way.
Right. My dad's almost 80.
Absolutely, and
he's black.
I don't mean to suggest that there are not elderly people or that they are not.
And what does it matter? What difference does it make whether the statistics? What does that matter to the individual voter?
It matters not at all to the individual voter.
So your statement was also irrelevant. Is that true?
The statement was addressing a specific assertion related to law enforcement.
Basically, your statement that minorities don't become elderly the way white people do has no relevance to whether an individual voter ID bill should apply to minorities or seniors. Isn't that right? Just doesn't matter. So if it doesn't matter, why are you making the point?
I was trying to address how I ran the presumptions that I made.
Right, presumptions
that I made.
Presumptions, which is similar to the word assumptions.
Right.
Which is similar to the concept of stereotype.
I had assumed.
Right. Let me ask you this. What's a poll tax?
A poll tax is a requirement that someone purchase or pay a tax solely for the purpose of voting.
Does the 24th Amendment speak to poll taxes?
It does.
What does it say about it?
I would do not have the text of the amendment.
I didn't ask you for the text. What does it say about it? I didn't ask you for the text. What does it say about it?
It bans the poll taxes.
And so as a poll tax is a fee that is required for a voter to pay before they can vote, right? Yes or no?
Yes, a poll tax would be such a fee.
What's the cost of getting an ID for a person who doesn't have one in, say, Georgia?
The IDs are available without cost in Georgia.
Okay, so there's no cost to it. What about the information you need to get an ID?
At the present time, there's no cost, as I understand.
No one has to pay. So Georgia IDs are free to all people. Is that right?
Georgia now has a free ID available in every county to voters.
So you don't have to pay. So I can go into Georgia and say I want an ID, and nobody's going to ask me to pay anything.
I forget the precise things, but there's no fee. And the case.
Yeah, and this is in regard to income or anything. They're just free.
At the present time, yes.
Okay.
Previously, there had been an indigency requirement.
So the Secretary of State, the state of Georgia, just foots the bill on that.
I don't know how the bill.
What about in Indiana? Is it free there?
I'm not familiar with Indiana.
Last question.
One last question.
Arizona.
I'm not familiar with Arizona.
Maybe we'll get a chance to come back.
The time of the gentleman has expired. We have votes coming up. I'd like to ask I recognize the gentleman from Virginia, Mr. Scott, for 5 minutes.
Thank you. Mr. Senator, I just have a couple of quick questions to begin with. Under the Voting Rights Act that we passed last year, if you have a majority-minority district, you can't dismantle that to create two districts in which the minority community cannot elect a candidate of its choice. If they'd been electing a candidate of their choice in a majority-minority district, you can't dismantle that and create two districts where that's not the case. Is that right?
I believe that would be objectionable.
Okay, now if the district is not technically, arithmetically a majority, but the minority community has routinely elected candidates of its choice reliably and predictably. Can you dismantle that district? Is that district protected under the Voting Rights Act?
I think that that's the 50% question currently is an open question under the law.
Well, would you pre-clear a district, 49%, that had been where the African American community had elected a candidate of its choice, and the submission has 2 districts where the community cannot elect candidates of its choice? Would you pre-clear that?
I do not believe that I would.
Okay. Now,
but I should stress that each of the submissions is decided on its own facts in the law at that time.
Well, I'm asking you if it was submitted this afternoon, would you pre-clear it?
No.
Okay. If the minority community can't elect a candidate of its choice by its own, but is reliably part of a coalition that does elect candidates, and the coalition cannot elect candidates without the overwhelming support from the minority community, and the submission dismantle that district, it's called an influence or coalition district, would you pre-clear that?
I think as we get into different issues, the facts of a specific case and the reliability of coalitions is going to affect the decision making. But the law clearly bans a retrogression in minority voting.
And you would count a coalition district going to a district where there is no influence as retrogression?
I think a plan that reduces minority voting strength is going to be objectionable.
Okay. Now, do I understand that the voting rights section of the Civil Rights Division is subject to an pending employment discrimination complaint?
I'd be very happy to discuss personnel matters with the committee in an appropriate forum. Obviously, there are important privacy interests involved.
Is that a yes?
It means that I would be very happy to discuss such issues in an appropriate forum.
Well, can you say whether or not partisan politics was illegally involved in employment decisions that are subject to those complaints? Whether or not partisan political considerations were illegally involved in employment decisions in your division?
In the voting section, they have not been a factor at all in my watch.
Now, you have apologized for those bizarre remarks. And following up from the comments from Mr. Ellenson, after all is said and done, is it your position that the voter ID laws do or do not have a disparate impact on African Americans?
I think that each state and each law must be looked at, and I have to keep an open mind on them. In Georgia, the facts showed the absence of discrimination. The federal court found an absence of racial discrimination, and the case has been dismissed.
The case was dismissed after they changed the law after the first submission. Is that right?
The case was dismissed after that, but prior to that, they found the absence of, or they rejected the racial discrimination.
Can you fail to pre-clear something without sign-offs from higher-ups?
Yes, I have the authority to pre-clear voting changes without sign-off from anyone else.
Now, as I understand in the Georgia case, 4 of the 5 members on the team recommended disapproval. Is that right?
I understand that there have been public comments to that effect.
Public comments say that Mr. Berman, Ms. Zabrinsky, Ms. Moss, Mr. Moore all recommended no, and Mr. Rogers recommended yes. Is that right?
I can only speak to the public comments.
The public comments also say that Mr. Berman had been working in the division for 28 years, Ms. Zabrinsky 5 to 6 years, Mr. Moore 5 years, Ms. Moss 3 years. Is that about right?
I don't know.
And that, well, you don't deny it. And Mr. Rogers, how long had he been working for the division?
Short period.
3 months?
I don't know the precise time.
I just have one further question, Mr. Chairman, and that is, did you have an award ceremony where everybody in your division but 2 received an award?
No.
have virtually all of this. Did Mr. Rogers receive an award, an on-the-spot award?
I have heard that.
And were the other people who disagreed with the Georgia decision reprimanded?
No.
Thank you, Mr. Chairman.
Thank you. We have to go vote now. I want to thank Mr. Tanner for his testimony. We have 3 votes. We will come back probably in about 15 minutes. Since we have another committee following this, I urge everyone on the committee to come back, on the subcommittee to return as soon as we get to the last vote on the floor, when we'll hear the second panel. Thank you. The committee stands in recess. Members for returning, those who have. The subcommittee will resume, and we'll begin by my introducing the members of the second panel. First is Lachlan McDonald. Since 1972, Lachlan McDonald has directed the Voting Rights Project of the American Civil Liberties Union in Atlanta, Georgia. Before that, he taught at the University of North Carolina Law School and practiced law, specializing in voting rights and discrimination cases. He has argued cases before the U.S. Supreme Court, testified frequently before Congress, including this subcommittee, and written for scholarly and popular publications on civil liberties issues. His most recent book is A Voting Rights Odyssey, Black Enfranchisement in Georgia. Toby Moore, Dr. Moore served as a political geographer and redistricting expert for the voting section of the Civil Rights Division of the Department of Justice from 2000 to 2006. In that position, Dr. Moore analyzed local and state voting systems under the Voting Rights Act and other legislation and supported department litigation efforts. He also monitored the conduct of elections and negotiated redistricting agreements, winning 3 Department of Justice Merit Awards for his work. Following his government service, Dr. Moore served as project manager at the Center for Democracy and Election Management, developing the reform agenda for the Commission on Federal Election Reform, chaired by President Carter and former Secretary of State James Baker. He's the author of numerous scholarly papers and presentations on voting and election issues. Bob Driscoll is a partner in the Washington, D.C. office of Alston and Byrd, with a diverse practice focusing on, among other things, civil rights matters, including assisting with a pre-clearance of a state redistricting plan under Section 5 of the Voting Rights Act. From 2001 through 2003, Mr. Driscoll served as Deputy Assistant Attorney General and Chief of Staff for the Civil Rights Division of the United States Department of Justice. In addition, Mr. Driscoll served as a commissioner on the Brown v. Board of Education 50th Anniversary Commission. Excuse me. A commission created by statute to commemorate that landmark decision. Julie Fernandez is a senior policy analyst and senior counsel at the Leadership Conference on Civil Rights, the nation's oldest, largest, and most diverse civil and human rights coalition. As members of this committee will no doubt recall, in 2006, Ms. Fernandez was active in the civil rights community's successful effort in support of the reauthorization of the Voting Rights Act of 1965. Before joining the Leadership Conference, Ms. Fernandez served as a trial attorney in the Civil Rights Division of the Department of Justice and was counsel to Assistant Attorney General for Civil Rights, Bill Ann Lee. As a reminder, your written statements will be made part of the record in its entirety. I would ask that you now summarize your testimony in 5 minutes or less. To help you stay within that time, there's a timing light at your table. When 1 minute light remains, the light will switch from green to yellow and then red when the 5 minutes are up. Before we begin, it's customary for the committee to swear in its witnesses. If you could please stand and raise your right hand to take the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? Thank you. Let the record reflect that each of the witnesses answered in the affirmative. You may be seated. Mr. McDonald, I don't know why it's in this order. It's not the order you're seated in, but anyway. Mr. McDonald, you may begin. Could you use your mic, please?
Is it on?
Now it is.
Okay. As we know, the voting section of the Department of Justice has a major role in protecting and enforcing voting rights. One of its most important duties is conducting administrative review of voting changes in jurisdictions covered by Section 5 of the Voting Rights Act. But unfortunately, Recent revelations of partisan bias in its decision-making seriously undermine the section's enforcement of Section 5. Partisan bias breeds a lack of confidence and trust in the section. Indeed, it creates a lack of confidence in Section 5 itself. It's a signal that partisanship may trump racial fairness and thus increase the likelihood that minorities will be manipulated to advance partisan goals. And it also shifts the burden of proof and enforcing voting rights to those who have been the victims of discrimination in contravention of the intent of Congress in passing the original Voting Rights Act of 1965. And one recent example of partisan bias infecting voting section decision-making is the pre-clearance of Georgia's photo ID law. In 2005, the legislature, in a vote that was sharply divided on both racial and partisan lines, passed a bill that required a person voting at the polls to present one of 6 specified forms of government-issued photo ID. Those who didn't have one would have to purchase one at the cost of $10. That was later raised to $20. The stated purpose of the bill was to prevent, quote, voter fraud, end quote. But not only was there no evidence whatever of fraudulent in-person voting, but there were already sufficient criminal statutes on the books that could deal with the problem, which was not, in fact, a problem. The photo ID requirement would also have an adverse impact upon minorities, the elderly, the disabled, and the poor. Kathy Cox, the former Secretary of State, has found that nearly 700,000 Georgians who were registered to vote lacked a driver's license, which is the most commonly available form of photo ID. She also has found that voters who lacked a photo ID were disproportionately elderly and minority. Today, in 2007, the state's own figures show that 50% of those on the voter registration list who do not have a driver's license are Department of Driver Services identification or African Americans. There were 22 counties that held special elections in 2007, and 58% of those on the voter registration list who did not have a driver's license or identification were black. Aside from its impact, there is also evidence that the photo ID law had been enacted with a discriminatory purpose. Representative Sue Burmeister from Augusta, a chief sponsor of the bill, told staff members in the voting section that if black people in her district, quote, are not paid to vote, they don't go to the polls, end quote. And if fewer blacks voted as a result of the photo ID requirement, it, quote, will only be because there is less opportunity for fraud. The Department of Justice approved Georgia's photo ID bill despite the near unanimous recommendation of the career staff to object. And according to newspaper accounts, one of those who played a central role in overriding the recommendation of the career staff was Hans von Spakovsky, a Bush appointee and counsel to the Assistant Attorney General for Civil Rights. The staff recommendation was not only overridden, but the leadership of the voting section instituted a new rule prohibiting the career staff from making recommendations in the future whether or not to object to proposed voting changes. This was a reversal of a long-standing section policy and has the effect of marginalizing the career staff with their experience and expertise in administering Section 5. And also, unfortunately, it would be easier now to make partisan-driven decisions by not having to override the recommendations of the staff. Not just the newspaper articles have made such reports, but Joseph Rich, who served as chief of the voting section from 1999 to 2005, described the failure to object to the Georgia photo ID bill as, quote, the brazen insertion of partisan politics into the decision-making under Section 5, end quote. And Rich's comments were echoed by Bob Kingle, a lawyer who spent 20 years in the Civil Rights Division and served as deputy chief of the voting section. Notably, in 1994, Deval Patrick, the then Assistant Attorney General in the Civil Rights Division, objected to a similar photo ID requirement from Louisiana. He concluded the state failed to carry its burden of proof that the change would not have a retrogressive impact upon minority voters. And let me just conclude by saying that the Department of Justice's pre-clearance of Georgia's photo ID law and its continuing support of that decision undermine seriously the effective enforcement of the Voting Rights Act.
Are you finished?
I'm finished, Mr. Chairman.
I thank the gentleman. The chair will now recognize himself for 5 minutes. Oh, I'm sorry. Mr. Driscoll. Mr. Moore. I should look at the notes here, not at the order there.
Mr. Chairman and members of the committee, thank you for the opportunity to speak about my experiences as the geographer of the voting section of the Civil Rights Division from 2000 to 2006. My service in the section was the highlight of my professional career. For a white Southerner born a year after the passage of the Voting Rights Act, and having devoted my career to studying both the South's sad racial history and its remarkable progress, enforcing a federal law born on the Edmund Pettus Bridge in Selma, Alabama was a high honor indeed. I'm also somewhat uncomfortable testifying. I had a very friendly relationship with John Tanner for most of the time that I worked with and for him, and speaking publicly about internal DOJ deliberations is not something I do lightly. Nonetheless, I hope that my experience at the ground level of voting section enforcement may be of some value to you in your oversight duties. Mr. Tanner's public comments earlier this month in Georgia and California could be overlooked if they were merely off-the-cuff remarks. Unfortunately for minority voters and unfortunately for the Department of Justice, the comments are actually a fair example of Tanner's approach to facts, the truth, and the law. Broad generalizations, deliberate misuse of statistics, and casual supposition, in my experience, were preferred over the analytical rigor, impartiality, and scrupulous attention to detail that had marked the work of the section prior to Tanner taking control in 2005. This decline and the myriad other problems that have developed in the section over the past several years are a direct result of the actions of political appointees such as Hans von Spakovsky and Bradley Schlossman. It has left behind a demoralized section, a growing list of lost court cases, and a severely diminished public trust in federal voting rights enforcement. While my written testimony discusses problems with other matters, including enforcement of Section 203 and the Ohio investigation in 2004, in the interest of time, I will focus here on the Georgia ID investigation. While it's not my intent to debate the merits of voter ID laws, I would like to point out that even by the standards of subsequent voter ID laws, the Georgia law in 2005 was a nasty piece of legislation. No state endeavoring to pass a photo ID law now is considering the kind of draconian restrictions the DOJ endorsed in Georgia in August 2005. The restrictions that President Carter and Secretary Baker explicitly labeled as discriminatory when I worked for the Carter-Baker Commission at American University. Personally, I think that the issue is overblown on both sides, but clearly history, as well as the federal and state courts, will record that the 2005 Georgia voter ID law, pre-cleared by the Department of Justice, was a discriminatory one. All of us assigned to the investigation realized the Department was almost certain to pre-clear it. Given the off-stated views of von Spakovsky and Tanner's eagerness to please him, none of us thought the Department would lodge an objection. We simply wanted to do our jobs. That we were not allowed to do so demonstrates how the mission of the section has shifted from a search for evidence to support decision-making to a search for evidence to support decisions already made. I only have time to mention a few of the statistical errors, procedural violations, and misrepresentations that I discussed more fully in my written testimony. First, it is not true that racial data from the Georgia Department of Driver Services indicated that blacks were more likely than whites to have ID. It was not true in any of the data submissions from the state. The only way you reach that conclusion is if you include hundreds of thousands of non-citizens who are not black in your comparison. Mr. Tanner compares the number from the DDS to the VAP and not the citizen VAP, which is the more appropriate comparison if you're to use that data at all. And there are reasons in my written testimony why I don't think the data is trustworthy at all. It is not true that minority voters die before growing old. What this misses is the fact that black voters in Georgia who are elderly are more likely to be impoverished and therefore, I think, more likely not to have ID. This data that Lachlan referred to from Georgia in July of 2007, in fact, shows that African Americans make up 40% of those elderly voters who lack ID. Behind all great lies is a kernel of truth. It is not true that Tanner's pioneering actuarial theory was ever part of the 2005 analysis, but is instead a post hoc justification for an unjustifiable decision. It is not true that we were not reprimanded. We were each called into the office one by one and told that our performance during the Georgia ID was not up to the standards of the section. Now, it did not result, in my case, in any letter of reprimand, but we were certainly reprimanded, and Mr. Tanner needs to correct that statement. It is not true that a group of prominent law professors made racist statements about the impact of the ID law, that Mr. Tanner dismissed as bizarre and offensive. And it's not true that we did not consider the poll tax. From Mr. Ellison's questions, the IDs were not free under the 2005 law. It was only under the subsequent 2006 law that the IDs were made free. To wrap up, John Tanner is both the cause and effect of the politicizing of the Civil Rights Division and should not be allowed to hide behind a career status which he has abjured by his actions. Until someone in the department, in this administration or the next, admits to the mistakes of the past several years and restores credible leadership, the voting section of the Civil Rights Division will remain a wounded institution. How long will the Department of Justice tolerate chronic mismanagement simply to save face? Thank you for your attention to this matter and for the opportunity to testify. I would, of course, be happy to answer any questions.
I thank the gentleman. Mr. Driscoll is now recognized for 5 minutes.
Thank you, Chairman Nadler, members of the subcommittee, for the opportunity to discuss the important work of the Civil Rights Division, and particularly the voting section. I just want to touch upon a few areas, and I'll deviate from my written remarks a little bit to respond a little bit to what's been said. Because I think this is a constructive dialogue, and this panel in particular can be very helpful to members of the committee and to the public in terms of understanding how voting rights enforcement works. We've got a subcommittee here, members are also of a full committee, that has great influence on the laws of this country and what they are. And at the end of the day, it's the members of Congress that set what those laws are. And I think that's something that we all have to keep in mind when we're complaining about voter purges or things like that that might be required under, for example, the NVRA. If there are provisions like that that are a problem, everyone needs to know that. We've got former career employees, such as Dr. Moore, testifying today. And career employees are the backbone of the division. They work for a long time. People like Mr. Tanner worked for 30 years in the division enforcing the laws passed by Congress. And everyone needs to understand the valuable work they do. I think Dr. Moore here as well, provides a service to some of us at least by making clear that the notion of career and nonpartisan are not equivalent, and that career employees can have just as many partisan leanings as any political appointee to ever come down the pike. We have advocacy groups such as Mr. McDonald, Ms. Fernandez represent, the ACLU, or the Leadership Conference, and they have a valuable role to play. They come to the department, come to Congress, encourage the department to enforce the laws and point out where the department's not doing a good job. However, I think people need to keep in mind not doing what an advocacy group wants is not tantamount to failing to enforce the civil rights laws. I think Mr. McDonald and Ms. Fernandez would admit, if members would question them, they're opposed to voter ID laws, period, as a matter of policy. It's a perfectly valid policy position to take, but their groups did not need one piece of data or evidence to reach the conclusion that the Georgia ID law was objectionable. And so what then needs to happen under Section 5 preclearance is, in light of that entire constellation of statutes passed by Congress, regulations enforced by the department, data submitted by the state, data submitted by advocacy groups, and analyses prepared by career staff, it comes down to the Assistant Attorney General, who is confirmed by the Senate, presidentially appointed, congressionally approved member of the department, who has to eventually make the call. And that leads to the final point I would like to make, which I think from an institutional perspective, I say this not as a former Republican appointee, but I say it as someone with a great affection for the department. I think it's extremely risky institutionally to call people like Mr. Tanner before this committee and to question them as he was questioned in the first panel this morning. He's a career employee. He's dedicated his life to trying to enforce the laws as best he can. And at the end of the day, the responsibility for what the department does lies with the Attorney General, lies with the Assistant Attorney General for Civil Rights. And I have no problem at all if this committee or any committee want to haul a political appointee before them and read them the Riot Act. But I think when the parties are reversed or there's a different administration in power, people could regret the precedent that was set today of taking someone who's a career employee who is not ultimately the one who has to make the final call on something like Georgia ID before a committee like this. And so again, I think these are the main points I'd like to make. I look forward to engaging in dialogue with members of the subcommittee, and I think this can be an incredibly productive hearing. Thank you very much.
I thank the gentleman. Ms. Fernandez is recognized for 5 minutes.
Good afternoon, Chairman Nadler, Ranking Member Franks, and members of the subcommittee. Thank you for the opportunity to appear before you today to discuss the voting section at the Civil Rights Division. Every week, it seems, there's another article in the news that calls into question the integrity of the managers and political staff who run the voting section at the Civil Rights Division and the priorities they choose to enforce. We read of political hiring, unethical conduct, partisan interest trumping law enforcement. We also learn that while there has been an increase in some areas of enforcement, much of the core work of the section has been significantly diminished. In many ways, the voting section has become the truest example of civil rights gone wrong at the Department of Justice. The voting rights movement was born of a need to repair decades of state-sanctioned denial of political equality to millions of American citizens. In years past, addressing this unfinished agenda guided the voting section's work. However, in recent years, the voting section has turned away from its historic mandate. Since 2001, the Civil Rights Division has brought 2 cases alleging voting discrimination against African Americans. One in Crockett County, Tennessee, was authorized under the previous administration, with the complaint finally filed in April 2001. The other was in 2006 in Euclid, Ohio. No cases involving voting discrimination against African Americans have been brought in the Deep South throughout the entire administration. None. The only case brought alleging racial discrimination in the Deep South was a case to protect white voters in Mississippi. Of course, white voters are protected by the Voting Rights Act, but it strains the imagination to believe that the only example of racial discrimination in voting in the Deep South for the past 6 years was a case involving white voters. While all of us understand that different administrations have different enforcement priorities, it simply can't be a priority for the Civil Rights Division not to bring cases on behalf of African Americans. In recent years, instead of promoting access to the polls, the voting section has used its enforcement authority to deny access and promote barriers to block legitimate voters from participating in the political process. This effort was driven in large part by partisan political operatives like Hans von Spakovsky and Bradley Schlossman, though in some instances with the complicit acts of career staff. For example, the division's failure to block the implementation of Georgia's draconian voter ID law in 2005, an outcome driven by von Spakovsky, and later held unconstitutional and characterized as a modern-day poll tax by a federal judge, opened the door for states across the country to pass similar onerous laws. In recent years, the voting section has sent a strong message to states that the federal government will not challenge voter ID laws, no matter how restrictive and no matter what the impact on minority voters. The section's abdication of their role to challenge discriminatory voter ID laws gives the impression that the section is being used as a tool to press a partisan interest in promoting voter ID. Furthermore, the division has rejected numerous requests from voting rights advocacy groups to enforce that part of the NVRA that requires social service agencies to provide voter registration opportunities, despite substantial evidence that registration at those agencies has plummeted. At the same time, the section has shifted its priorities to enforcement of voter purge provisions of the law, which in many cases, as Congressman Wasserman Schultz pointed out, as in Florida 2000, resulted in thousands of legitimate voters being taken off the rolls and denied their right to vote. And the Department of Justice's Voter Integrity Initiative, established in 2001 by former Attorney General John Ashcroft, has created unnecessary commingling between criminal prosecutors in the U.S. Attorney's offices and Civil Rights Division attorneys. These efforts can, if done improperly, result in a chilling effect on the participation of minority voters, particularly in jurisdictions where there is a history of disfranchisement efforts targeting racial and ethnic minorities. Rather than promoting schemes to deny equal opportunity for citizens to vote, the Civil Rights Division should be focused on, 1, combating voter ID laws that have a disproportionate negative impact on racial, ethnic, or language minorities, like those passed by the Georgia legislature. 2, ensuring that states are complying with the NVRA's access requirements and ensuring that those registrations are processed appropriately. And 3, reinforcing the firewall that exists between the Civil Rights Division and the Criminal Division's work to combat voter fraud. Members of the committee, the work of the Civil Rights Division over the past 50 years has helped to transform our nation into a place where equal opportunity can be more than a dream. Today, we must not allow those who seek to undermine civil rights destroy the power and credibility of one of our most important institutions in the fight for equal justice. We must expect the Civil Rights Division to enforce the nation's voting rights laws without fear or favor, and we must demand accountability when they don't. Thank you very much.
Thank you very much. The chair will now recognize himself to begin the questioning with 5 minutes of questioning. Mr. McDonald, you said a recent study by Professor Minute shows that between 2002 and 2005, only 24 people nationwide were convicted or pleaded guilty to federal charges of illegal voting. We heard a previous witness, or actually I don't think it was a previous witness, I think it was the ranking member, talk about how 400,000, or maybe it was both, anyway, 400,000 people allegedly were enrolled in in Florida and some other states, and 140,000, lots of people, and 2,000 people actually voted in 2 states. Can you comment on this? I recall seeing reports that this was not true, but do you have information on this, especially given the studies you cite?
We're involved in litigation both in Georgia against the constitutionality of the photo ID law and also in Indiana, and there is absolutely no evidence of any kind that there has ever been any fraudulent in-person voting, and that's the only kind of election fraud that the photo ID bills are allegedly designed.
There's no evidence that 2,000 people voted in New York and Florida at the same election? The same 2,000 people?
Well, I'm not familiar with those facts, but what I do know is that the justification for the photo ID law as a way of combating in-person voter fraud, and in fact there is no evidence whatsoever that there's ever been any in-person voter fraud. So it's a bill that addresses a problem that does not exist. And about the double voting, I would just remind members of the committee that the courts have held that it's not unlawful to vote in 2 different jurisdictions. There are some states that will allow you, if you're a non-resident, to vote in that jurisdiction's elections if you're a property owner.
But you can't vote in the presidential election in 2 different states on the same day.
That would not be appropriate. That would not be appropriate. But the mere fact that you're voting in 2 different jurisdictions doesn't necessarily mean that that's unlawful under the state law.
Okay. Now, Mr. Moore, you heard Mr. Tanner testify that that he made the decision on the Georgia case. Did I hear you say that Mr. Spikowski made the decision?
No, I think that the 2 of them handled it pretty well. I mean, I think John knew what Hans wanted it to be. Hans had made it pretty clear. So technically, who made the decision is almost immaterial.
And they made now. I understand that Georgia sent information on the 26th of August. On the 25th, the section people said, don't pre-clear. On the 26th, Georgia sent information about 600,000 incorrect data about 600,000 people. And on the 26th, it was pre-cleared. Did they have time to analyze the correction of the data about the 600,000 people? Did they bother? Was it analyzed?
No, sir. I don't think they ever analyzed it at all.
So they just, even though they knew it was mistaken because Georgia told them, we're correcting our data that we gave you.
I don't think that data was ever analyzed.
And now it's your testimony that Mr. Tanner refused to answer the question whether he overruled 4 of the 5 analysts, but he did overrule 4 of the 5 analysts.
Absolutely.
And the only analyst who decided it, who thought that the law should be upheld, should be pre-cleared, was a fellow who'd been hired politically in the what we now know is politicized hiring of the Justice Department only a few months previously.
That's what. Yes.
Okay. Let me ask you: is my understanding that of the 26 analysts that were present, prior to 2001, there were 26 civil rights analysts and 6 attorneys who reviewed submissions, gathered facts, and made recommendations on over 4,000 Section 5 submissions each year. It's been reported there are significantly fewer staff members processing the same Section 5 submissions, many of whom are recently hired employees with no prior experience with Section 5. It's my understanding that of the 26 analysts, only 8 are left. Is that correct?
I have not worked in the section since 2006, so I don't know how many analysts are working.
Well, are you aware of, how would you characterize the ability, does anybody know about those figures on the panel? All right. Well, Mr. Moore, do you know about the capability of the voting rights section of the Section 5 section to do its work today in terms of its
From
staffing?
Conversations with my former colleagues, I have some picture of what it's like to work in the Section 5 enforcement.
Can you tell that to us?
Is that there are a small number of analysts who are very overworked and who work for acting deputy chief who has created somewhat of a hostile work environment and who's it's a very bad situation.
What do you mean by hostile work environment?
Well, I'm sorry, it's kind of secondhand, but my conversations have been that it's a very unhappy place to work.
And why do you think so many staff have left the voting division, the voting section?
I think, like me, they didn't really feel that there was any sense in doing their work if it didn't make any difference on the decisions that were being made.
And you think that the work of the analyst does not make a difference to the decisions?
Well, there are a number of Section 5 submissions that are not controversial, and their work is enormously valuable. But on anything of significance and of controversy, no, the decisions are being made for political expedience, in my experience.
The political decisions on important Section 5 matters are being made for political expediency and not on the merits.
That was my experience in Georgia.
Thank you. I thank the gentleman. I now recognize for 5 minutes the ranking minority member.
Thank you, Chairman Nadler. We're under the... Oh, excuse me.
Thank you, Mr. Chairman, and thank you, Mr. Chairman. Mr. Chairman, I hate to start off my questions here with a little bit of a downer, but I was disappointed in some of Mr. Moore's characterizations of the former witness, Mr. Tanner, in that...
I think they were very generous.
Well, they were pretty generous, but and unfortunately to suggest that Mr. Moore was saying that black people and white people age differently. I think if you read the context, the man made a very clumsy and awkward statement for which he apologized for the awkwardness of it and the misunderstanding of it, and simply tried to explain that his purpose in making the statement was to point out that due to some of the circumstances in society that sometimes minorities in our country tragically and sadly live to a lesser average age than some of the majority members of society, and that is a tragedy. But unfortunately, Mr. Tanner's remarks seem to be pretty twisted here. And I didn't come to defend the guy, but Mr. Moore also says he thinks someone did that, or he didn't think someone did that, or that I don't know if he's relying on experience, or he's just kind of trying to add a kind of a partisan element to the situation. And I just had to point that out. The Carter-Baker report concluded that voters in nearly 100 democracies use a photo identification card without fear of infringement on their rights. These include many countries that are much less wealthy than the United States, including India and Pakistan. They don't agree on too many things, but they do agree on the need for photo IDs for voters. Mr. Driscoll, would you comment on that? In other words, let me put it like this. Oftentimes the reason people don't vote is because they don't have confidence in the system. They don't know that their vote's going to be counted. They don't know that somehow that other distortions in the system are going to diminish their vote. And one of the things that I believe increases that confidence is having a consistent voter ID to where people know that the people voting are the ones of that district, and that they are citizens, and that they have the right under the Constitution to vote. And so, Mr. Driscoll, would you just comment on the confidence factor, and what do you think that means in the bigger picture?
Thank you for the question. I'd like to answer that in two parts. The first is that I think both the Carter-Baker Commission and, more recently, I think the Supreme Court in Purcell have recognized the point you're making, that voter integrity provisions can increase confidence that the system works, and therefore can drive turnout up, which is something everyone wants. And I think there's a policy matter that I happen to personally agree with. The only caveat I want to put on that, and this is a very legitimate caveat, is we can't forget that we are in a country with a huge history of discrimination, and that the Voting Rights Act was passed for a reason, and Section 5 exists for a reason. And so in that context, the Civil Rights Division needs to analyze any particular ID requirement to determine whether or not it, in fact, has a retrogressive effect. Because if it did have a retrogressive effect, it should not be pre-cleared, and it should not go into effect if it's in a covered jurisdiction. And so I think that there's a legitimate policy debate. I happen to think voter ID on the whole is a good thing, and the benefits outweigh the cost by far. But I think that is a separate question from whether or not any particular law in a covered jurisdiction should be pre-cleared, and I think that question will come out differently on a case-by-case basis. I think that Georgia was pre-cleared. I think there are other laws that might not be, and unfortunately you need to be a professional statistician, I think, to make those calls on a case-by-case basis. But I think that's how I would answer the question, that I think you're absolutely right that people have pointed out the need for confidence in the system, and ID helps to enhance that in some respects. But certainly the Section 5 analysis needs to be done independent of that policy judgment.
Thank you, Mr. Driscoll. Mr. Chairman, I guess I just want to point out here, without asking additional questions, and I truly believe that it is one of the critical things in our country to make sure that people of all races, all factions have every opportunity to exercise their constitutional and God-given right to vote in this country. And I want to see that happen in every case. But I'll just quote a little something that came from the discussion between Mark Hearn and one of the Democratic members of the Carter-Baker Commission, and it echoes the feelings of former mayor of Atlanta, Andrew Young. He said, "For our base, who may not believe their vote will count, a voter ID will give them greater confidence that they will be allowed to cast a ballot when they go to the poll, and a greater confidence will increase participation. We can say, go to the poll, show the election officials your card with your picture on it, and they will guarantee you can vote and your vote will count." And I truly believe that if we make sure people have confidence in the system, we will help minorities more than we will any other way. Thank you, Mr. Chairman.
I thank the gentleman. We have another committee waiting to use the room, so I'm going to be a little more strict in enforcing the 5-minute rule. Who's next? The gentleman from the distinguished chairman of the committee, Mr. Conyers.
Thank you very much, Chairman Nadler. First of all, I want to thank Trent Franks for being here during and throughout and contributing to this subcommittee hearing, because to me this is extremely important. And I want to commend Bob Driscoll as the minority witness, who brings a committed attitude to this subject. When you say that we all want to increase voter registration and turnout, that's the key to what we're all doing, and then have the votes count. That sums it all up, and I thank you both very much. We're in such a time constraint, Chairman Nadler, that I want to recommend that we consider holding an additional hearing, because there is so much to go through here. I'm going to be going through this testimony very carefully, because, look, there's two views of this. One is that This voter rights section is red hot. It's going great. Things have never been so good. We're getting more votes. We're getting more cases prosecuted. Everything is hunky-dory. And then we have the other view in which a number of people are calling for the section chief's resignation as we speak. The Inspector General's office has multiple investigations going on, not only about the activities publicly and privately of the section chief, but of career members as well. So, look, and this isn't the first time I've ever heard this kind of disparity in committee hearing. But there's only one thing that I'm here for right now. Where do we go from here, lady and gentlemen? What is it that we need as the committee of jurisdiction, both the subcommittee and full committee? What are we to do? And the three ideas that have been presented here is to review the effectiveness of senior management of the voting section and determine whether we need to make replacements or additions. Then a plan, number two, a plan to rebuild the core and Section 5 analysts. The attrition of 28 to 8 is far too drastic when we're racing against the clock to the first Tuesday in next November. The third, we must examine whether voter protection laws are being used to restrict voter rights. My bill, the second bill President Clinton signed in 1993, was the Motor Voter Act. And now it's being used to purge voters. And it's being underutilized to register voters. I heard Ms. Fernandez make a couple recommendations, and I'd like her to tell me about hers now, and then we want to look at them together for any additional comments that you may have.
Thank you, Chairman Conyers. I think you've touched on a few of them already. I think that because we have the Inspector General's investigation ongoing within the department, my understanding is that we should be anticipating a report coming out of that office fairly soon. And I think the committee may want to inquire with that office how quickly we can get that, you can get access to that report, and then review the recommendations and see if there are things that have gone on that could be change, whether it's in management or the politicization question.
Well, you're asking me to trust the report, and that's a good way to start.
I'm asking you to start with the report, not necessarily to trust it, but to at least start there, because I do think that there is likely to be a fairly thorough discussion around the politicization issue, though I have no inside knowledge of that at all. And I also think that the committee's work is so helpful in focusing attention on the NVRA and the way the NVRA has been used to do these broad purges that wipe out so many eligible voters for no gain. And even this question about people voting in, just to tie this together with the voter ID issue, people voting in Florida and New York, well, if they're registered in both Florida and New York, no voter ID is going to stop them from voting twice. So voter ID is not a cure for whatever kind of problem, which I don't know that much about, is presented. But I think that this committee putting pressure to build up that firewall between criminal and civil rights.
Is my time up already? Well, could I ask the gentleman here to please submit to me your recommendations? I would be deeply grateful for them. Thank you, Mr. Chairman.
The gentleman from Minnesota is recognized for 5 minutes.
Thank you, Mr. Chair. Ms. Fernandez, let's say that there have been, over the last 3-4 years, perhaps as many as 24 people who have been convicted for voting in a name that was not their own. How many people are we going to lose with these voter ID bills?
Tens of thousands, perhaps hundreds of thousands, depending on which bill it is. Some bills are much more onerous than others.
Yeah. Now you do this kind of work, and Mr. McDonald, you do this kind of work, and Mr. Moore, you do this kind of work too. I'm sure Mr. Driscoll as well. Is the main complaint black voters, Latino voters, that there's no is their main problem or barrier to voting that the fact that some states don't have a voter ID requirement?
No, and in fact, what this really is, I think, Mr. Ellison, I think this is people who are interested in having fewer people vote have kind of whipped up this whole notion of voter fraud in person. What we're talking about is in-person polling place impersonation, right?
Right, that's what we're talking about.
Intentionally impersonating someone else in the polls to vote, which is a high-risk proposition, carries criminal penalties. You'd have to create 500 to 1,000 co-conspirators to do it. It's an inefficient way to steal an election if you even want to do that, right? So we're talking about whipping up a fear of that practice, which is apparently non-existent, to justify voter ID laws.
Now, Ms. Fernandez, if you vote, if you're an immigrant person and you don't have a legal right to vote and you vote, isn't that like a felony?
You could be deported.
And so you're going to risk your life in America that you're trying to have.
Yeah, for what?
So you can to cast a vote. You know, in my experience, I have trouble getting people to vote once in their own name, as opposed to trying to round up a bunch of people to steal an election. Mr. McDonald, I want to ask you this question: Do you think that voters of color who want confidence in an election and want to believe that their vote really matters, is their biggest advocacy to have a voter ID bill passed in the various states? Is that what they think the answer is?
Well, I think that a photo ID bill that was passed, at least in part to discriminate, that plainly has a discriminatory impact, does nothing at all to create confidence in the fairness of the electoral system.
Mr. McDonald, let me ask you this question. Would having people in black police uniform looking outfits standing around polls, questioning people and telling them that they better have their child support paid or they're going to be arrested if they vote, do you think that might intimidate voters from voting?
Of course it would, and we know that those sort of voter intimidation tactics have been used in the past, and they ought to be addressed.
What about recent elections where they have these fake little memos and letters around saying that if you don't have your child support paid or your parking tickets paid, that you can't vote, or if your cousin doesn't have? I mean, there are letters like this. I'm sure you're aware of them. And this isn't 10, 20 years ago. This is last election.
Yeah, well, we have done monitoring of elections since the 2000 election, and we've found many examples of things that are unconscionable, efforts to target minority precincts, to deprive people of the opportunity to have access to assistance in voting, and also strong on...
Mr. McDowell, forgive my interruption, but these are the things that people are concerned about, isn't that right? And I'm just going to state for the record my own opinion, and forgive me for my interruption. I believe that voter ID bills are intentional voter suppression of minority voters and have the effect and intent of suppressing people's rights.
Yeah, there's one thing that I would definitely like to respond to, which has not been responded to, and that's Mr. Tanner's statement that the district court in Georgia found that the photo ID law did not violate the racial fairness provisions of Section 2. That is incorrect. The court granted a preliminary injunction, found that the photo ID law would have a negative impact on racial minorities, but it did not reach the Section 2 issue. It reserved a ruling on that. Then when it issued its opinion on the merits in which it reversed itself, it expressly did not reach the Section 2 vote dilution claim. And more importantly, last week we got a letter from the Court of Appeals questioning whether or not it had jurisdiction over the appeal we had taken of the case, because the court had not reached some of the claims that were raised, including Section 2. So the court did not resolve the Section 2 claim.
Mr. Chair, may I just say for the record that I think Mr. Moore is highly commendable, and he has done what I would expect a person born in the mid-1960s to do: carry on the legacy of the civil rights movement, make sure America is free and fair for everybody. I think you're a hero, Mr. Moore, and I'm so grateful for your advocacy and your honesty.
Thank you. Thank you. The gentleman's time has expired. The gentleman from Virginia is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. McDonald, I asked in the earlier panel about some questions that need to be resolved before we go into another round of redistricting, specifically whether or not coalition districts are protected under the Voting Rights Act. Are there any questions like that we need to make sure that are resolved before we get into the next round of redistricting?
Well, I think that if there is a coalition composed of racial minorities and others that has the ability to elect candidates of its choice, that that's protected against retrogression by Section 5.
Are there other questions that we need to look at to make sure that they are resolved ahead of time so that as states start doing their redistricting and localities start doing their redistricting, that there are questions that we need to look at?
Well, there's a question about whether majority-minority districts can be reduced on the assumption that there's sufficient white crossover voting to maintain the ability to elect candidates of choice. And I've discussed this issue with people in the state legislature whose opinion I deeply respect, African-American members, Tyrone Brooks, Robert Holmes. They have assured me that not a single member of the black legislative caucus would support reducing majority black districts below 50%. And the reason is that once a district becomes majority white, it behaves in a different way. You no longer have the level of white crossover voting that you might have had when it was a majority-minority district. You no longer have the confidence that minority voters have in it, and you no longer have as many minority candidates who are willing to run. So those districts will perform differently. And I take my cue from Tyrone and Bob Holmes.
Well, if you have districts that have, in fact, performed, you had several members of the Congressional Black Caucus who are in districts less than 50% black. Are those protected as minority districts where the minority community can elect a candidate of its choice?
I think so. That's me speaking now, not Mr. Tanner or the Department of Justice.
Okay. Are there other issues that we need to make sure we look at? Ms. Fernandez?
No, I think that's the central issue, and I agree with Lachlan.
Okay. Mr. Moore, is there any question that the voter ID bill had a disparate impact on the minority community?
We believe the state had not met its burden to prove that it did not. It was a complicated statistical record with no smoking guns. But
were there memos to that effect that were written?
I believe the Washington Post published the memo that we wrote. Yeah.
Did the Washington Post suggest that memos had been changed?
The memo that the Washington Post published, which was the final staff memo, was, in my view, doctored to remove the recommendation and to reverse many of our key findings.
Were there in the previous panel, I asked whether or not anyone had been reprimanded who did not agree with the final decision on the Georgia case. He said no one had been reprimanded. Is that accurate?
No, not if reprimand is an oral reprimand. If it was a written reprimand, perhaps, but it was not for an oral reprimand.
The four that disagreed were orally reprimanded?
I don't know about Mr. Berman. The other three of us were reprimanded.
Was partisan politics involved in any employment decisions in the voting rights section?
I was not involved with hiring. From the series of attorneys who joined the section in the last couple of years while I was there, either it was politicized or they got very lucky.
In investigating the Ohio irregularities, Mr. Tanner, a political appointee, did the investigation himself. Is that right?
Mr. Tanner is a career employee. Yes, he did.
He's career or political?
Career.
That's a good question. He's technically a career. He's a career employee.
That's a good question for you too.
I'm sorry. Okay. Was there a reduction in staff while you were there?
Yes, there was, but how much of that was a result of people leaving out of unhappiness, and how much of it was the natural cycle as the census to 2000 became further ago?
I have no further questions, Mr. Chairman. I'll yield to the gentleman from Wisconsin.
I thank the gentleman. On behalf of the subcommittee, I want to thank our witnesses for appearing here today and for your testimony in this very important question. And with that, and the thanks of the chair, this hearing is adjourned.